Good afternoon, Your Honor. My name is Charity Kisotu, a commissioner. You're most welcome.
Thank you so much.
Good afternoon, Your Honor.
Good afternoon.
My name is Nzilani Caroline. I'm a commissioner. Karibu sana.
Thank you so much.
Yes. Thank you, commissioners, for that introduction. Honorable Macharia Muriuki,
Yes,
before
my
we
lady.
delve into the interview, you can tell us your county and your ethnicity.
Thank you, my lady. I'm from Laikipia, a place called Ramuria, and I'm a Kikuyu.
Thank you very much,
Yes.
Commissioner Macharia. Will start us off.
Mheshimiwa, just a few questions.
Yes, Commissioner.
You have largely worked in the judiciary
Yes.
for many years,
Yes.
and I'm sure you appreciate the fact that there's quite a number of judicial officers like yourself who have applied also to join, to be elevated to the position of a judge. Now, it means then that you must be able to show us that you are extraordinarily good.
Yes.
Because if you come and state what is ordinary, what is expected of you as a judicial officer,
Yes.
then it means that there is nothing distinguished about you as an individual, as a JO.
It is true.
So could you please state, and you have to convince us by stating at least 2 or 3 things that you think you've achieved as a JO that makes you different, that is extraordinary.
Yes.
And in answering that, please avoid the normal.
Yes.
You're hardworking, you have been, all those things that everybody says that they have, and they.
Yes, Commissioner.
Yeah.
Could I maybe introduce myself briefly, so that? Yes, thank you, Commissioner. I'm James Macharia, currently the Senior Principal Magistrate in Tigania Law Courts. I have worked in the judiciary since 2008. I worked in Nyamira as a resident magistrate. I worked again in Keroka. Though I worked for 7 years in Kisii region. Then from there, I was transferred to Garsen, Tana River. I worked in Garsen for 5 years. And then, then I was transferred to Nyeri. I worked there for 3 years. And then I was transferred to Tigania, where I am now. Now, James Macharia holds LLB from University of Nairobi. And then in 2012, after the Constitution, I saw it fit for me to do my own contribution. I went back to school. 2012, I went and did my Master of Laws, Law Governance and Democracy. And my thesis was public participation in devolved governance, a method of reality, because I saw it fit that there were gaps, which I realized are there after the Constitution. So many cases were coming in, and I found it fit that I should go back to law school and do something. And for your information, I did a lot of contribution, and we have currently the Public Participation Bill 2023, and the recommendation in my thesis can say that quite a number of them have found themselves in the current Public Participation Bill. As if that is not enough, of course, I went back to school again. I'm currently a PhD student. I finished my coursework. I'm doing the law leadership and governance. That's what currently I'm doing. And the reason is I'm doing participatory performance in the devolved governance. So because I wanted to see, now that I have done this, the right to public participation, I have seen there are so many gaps here, and the decisions which are coming in. And I have made my contribution to say, this is what we should come up with, so that the citizenry, because it's not just illusory, citizenry could come and be able to be involved under the principle under Article 10 of the Constitution, inclusivity, public participation. So now I was saying, now because we have gone to that level, why can't I now see, now we have allowed the public to contribute. Can I now see, is there any correlation between the public participation that I have talked about? Is there any correlation with now the performance? So that now I'll be looking about the issue of gender, human right, public participation still a factor there. So that is just on the introduction basis. Let me now go to where I've worked, or the contribution I've made. I'm a person who is courageous. And you tell me, take your bag, go to Madeira. I'll not look back. I'll not look back. One of the issues, I was transferred and taken to Garsen. That time, we had just come from a lot of clashes. Pokomos and Orma were fighting that time. I went there. I stayed with that, and I said, how are we going to contribute? So many inquests are coming. People are being, even police officers are being thrown in Tana River and all those kind of things that were happening in that time. And I said, I must now get to know what is the composition of the CUC here, and how can I come with these two people, the Pokomos, who are the farmers, and the Oromas, who are, and then the Oromas, who are pastoralists by their trade. So we went through a CUC, and I was able to co-opt both sides who are not, they were not included in the CUC. So I made sure that on one side we have the Pokomo, and the other side we have the Oromas. And in that case, because there used to be a lot of tension when they were coming to court, they were armed with the arrows and everything. And in that, our CUC, we used to talk a lot and to say, how are we going to end these clashes and be able to perceive each other as? So I included them. And we had very good talks, very strong CUC with the members of even there was a peace committee that had appointed by the president there. We used to sit with them there. And within no time, so many cases had been withdrawn in Garsen. So many cases, because now there was that, even the distrust having come from the elections 2008 and everything, so that they are not one camp is not believing, I'm not believing that the other camp will get justice. Number two, human dignity at Article 28 of the Constitution, right to non-discrimination and equality, and Article 27. How have I gone to that? I was there, and it is me who opened the court, Garsen Low Courts High Court, and Emeritus Justice Maraga. He came there. And I can tell you, those people, because they were coming for 2 hours, all the way from Malindi, they used to be so wet, and the atmosphere there is very, 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 very hot. So I converted some cells into showers. My prisoners, I didn't need to go there. They used to shower. I have showers there because I said these are people who should be treated with dignity. So there were some rooms which had not been occupied. So I said I'm going to contribute, and these people are human. They must be treated as such. So I put showers where they could, even today, although they used to steal them and whatever, but I ensured that I did that. Okay? Then in Garsen, there was so many, a lot of disharmony, a lot of things which were happening. Especially there was a lot of clashes. After the clashes, the area where we are going for mobile, Kipini, and also we are going for mobile to E2, it was not accessible. But we could get the GSUs to take us there. And my people, I normally say, if you're going to shoot my people, shoot me first.
Yeah, that's right.
Yes.
Yeah, that's quite brave.
Yes.
Let me ask you.
So I made sure that I went to Kipini, did all what I did there, and ensured that the justice for people, I never missed any Kipini mobile court. I ensured that I went to Kipini and went, and everything went well. The issues of FGM, when I was in Keroka, I was able to resolve so many cases. FGM, we had just enacted the FGM Act. So many things was happening because the community could not believe in this law. And we talked to them and said, a woman, a girl has a right.
Yeah, that's
so
right.
Don't kindly do that. So we had so many CUCs, and we had, so it can be in my one of the booklets. You can see a lot of people are telling me, you have done well in our community. You have really, really assisted us.
Okay,
now in Mekidori, we have gone there. Right now, I saw they are suffering so much. And there's a building there. I have, with a member of parliament, we have converted a very good building.
Yeah, you'll be asked some of those questions later. Yeah. So my final question.
Yes.
I can see you now at SPM level, which is quite senior.
Yes.
But, there'll be, of course, openings that will also come for CM level. Yes. Don't you think that probably, you can rise now through that route of a chief magistrate? When those positions become available, you apply, then appear before the commission, prove yourself, get it, then be able to discharge your duties now as a chief magistrate, and then you continue rising, stepping, so that now, because you still have many years ahead of you, then ultimately you can now apply to be a judge. I don't know what you would say about it.
Yes, Commissioner, that is very good. A man without ambition is no man at all. Someone said that. I'm a ambitious person. I cannot sit back and say just because these positions are maybe CMs are the ones who should, maybe they are ranking higher than me. I should not. For your information, I was shortlisted for the interview of the CM, but I think there was a bunch that came first. So I even gave my information. So I have not been told by the JSC whether we are still going for the second batch, the people who have not been interviewed. So I'm a professional qualified magistrate as a senior police for magistrate for now 3.5 years. 16 years of career that I've given, competent service that is untraded, that has not been pitched by anybody. Yes.
Yeah, thank you very much. I think I can see your passion is palpable. You're able to demonstrate your passion to make sure that people access justice, and justice that makes sense to them. Well done. Now, we will come to another area of the law, and I will ask you questions on the family law.
Yes, family law. Yes.
There are a plethora of laws that protect family. Can you tell us which ones are those laws? The statutes that protect family.
Matrimonial Property Act 2013, my lady. I think we also have the Marriage Act 2014. Of course, the Supreme Law is the Constitution, and Article 25. Of course, I should not forget that one. What other one do we have? I think those are which come to mind.
Which one? Or those two?
The three area, the two: the Marriage Act, the Marriage Act 2014, the Matrimonial Property Act.
Okay.
I'm not sure whether we'll still apply the Married Women Property Act of 1882.
No, it was replaced by the Matrimonial
Act. Yes.
Yeah, but there is also the Children Act and the Law of Succession Act. We also have the Sexual Offences Act, of course, protecting the rights of especially the young. So now, tell us what law governs the rights and responsibilities of spouses in relation to matrimonial property.
I think the first one will be the Family Article 45 of the Constitution.
That is the Constitution.
Yes, that talks about equality of the parties, even during at the time of the marriage, during the marriage,
yes,
at the time of the dissolution.
Yeah.
Although we have the case law, the Supreme Court has really come out on that. I don't know whether I can explain that.
Which case law do you have in mind?
Yes, my lady, I have a case of Mary Nyambura versus Paul Ogari.
Yeah.
And I have another one for Joseph Ogentoto versus Mother Ogentoto.
What is the ratio in those cases?
Yes, my lady, these are two cases. The first one, maybe I can start with the one that for the one for Ogentoto versus Ogentoto. The court came up with it. This person had it is the issue of property where the dispute went to the High Court, and then went to the High Court, to the Court of Appeal, and then went to the Supreme Court. Court of Appeal decided, I think in the High Court was 30-70, Court of Appeal 50-50, and then the Supreme Court divided 50-50. And the court said very clearly at Article 45 that we must come and say that right to equality is not about equal sharing. It's about, we use the principle that Gizing versus Gizing, Lord Diplock, that equality is equity. So that a party must be able to demonstrate what and how he has contributed, so that he'll be able to get out of that marriage with according to his contribution. And
so you have to evaluate the contribution of each party.
Yes, for each party.
And what will guide you to find out the contribution by each party?
Yes, you look both the direct, the financial, and you're also going to look at both the indirect contribution of the parties.
So the direct and indirect contribution.
Yes, of the parties. So in that case, the Supreme Court was able to give, to have it divided 50-50 because the lady had substantially contributed by taking laws and all that. For the Miri Nyabura, I can also talk about it.
It's okay. I know you have the law in your fingertips on that. So we can go to the Evidence Act. And you can tell me the instances when the burden of proof is shifted. There are certain exceptions.
Yes.
Yeah.
Ordinarily, the standard is that the burden is the person who alleges. In a criminal case, it would be the DPP. There's the burden.
You arranges proofs,
Yeah,
but
yeah.
there are exceptions. Those are the ones I'm interested with.
Yes, I think it's when it comes to like a murder case where a person has been found and maybe you are the last person, maybe a person who was last seen with the deceased. It will shift now to say that the person has been found dead. Then the burden will shift in a way that to say to explain and circumstances. And because now these are now knowledge, these are you are the last person to be seen with the deceased. He has been found dead in your house. So now it come upon you now, it will shift to you now to come and show that indeed I was the deceased, I did not kill him. So you really have to explain circumstances.
Okay.
So yes, but
Any
evidentiary burden keeps changing.
Yeah.
Once you allege something, the evidentiary burden will change throughout the case.
I just wanted to hear the exceptions, and you have given
Yes,
one
that one
where
is
there are
that one.
circumstantial evidence.
Yes, the circumstances where you have to show. Yeah.
Any other?
I think where the honors generally will be on the person who
That's the only one. Okay. What is the most prevalent offense in your court?
Yes, my lady, we have a problem. Tigania, let me just say, Tigania is very litigious society. They like complaining. The information or the parties, they are normally family. Mother, father, father-in-law, daughter-in-law, the son, the mother. That, like, for example, okay, let me answer.
So family disputes.
Family dispute.
Succession, land matters.
Offensive conduct for criminal. They like using some bad words in their own language. It forms almost like 30% of our cases.
Okay.
Grievous harm, where you are either cut here, it is a short sleeve, or a long, if you want a long sleeve, you are cut here, stealing in the land.
Okay.
Or you decide.
So there's a short sleeve and a long sleeve cut.
Yes, they are very Tigania.
Okay. So how are you using the multi-door approach to bring harmony in that society so that they can live in harmony with each other and they reduce the number of cases coming to court? Yes.
My lady, when I reported in Tigania in May, so I'm exactly now, I think 11 months. And by the time I was reporting, I was in Nyeri, and I was given instruction specific by my RMC that you have been given special instruction to go at the the station, because that station had come from strikes by the advocates, collegiality, so many problems in Tigania hand. And you have not worked in Tigania, you have not worked in Kenya. Magistrates know that. So you have to work in Tigania to prove you are. So I went to the first thing, I had a bar bench with my advocates so that we identify the kind of the matters which are there and how can we now make this team here. So I did a very good case audit. I was able to see matters which are pending and everything. And then from there, we agreed on the way forward. Number two, I did the CUC. The same May, I think one was on 12th, the other CUC now was on, I think 20 something, the same month. So we had a very good talk with the CUC members and agreed some of these disputes which you are really bringing. I mean, there's no law that's
I think the other commissioners will ask you questions because I think you are dealing with a very unique station.
Yes.
But I hope you can also formalize your court annex mediation.
Yes, we can. We actually talk with the judge and we see how you can maybe give us a court where we can, some of these offensive conduct, they can be really resolved. Okay. But we have tried to apply HDR and everything at our disposal.
Okay. Yes. Thank you very much, Commissioner Orwanda.
Thank you, my lady. Good afternoon, Mheshimiwa.
Good afternoon.
Okay, I have a quick question for you. What is prima facie case?
Prima facie case is that case where a tribunal properly directing its mind to the evidence and the law applicable would ordinarily either convict or not convict is that case which has not yet, the other side has not been handed. So it is that case where a tribunal properly directed its mind to the law and the evidence would not convict, I think. So, yeah.
I need to be clear. Would convict or not convict?
Would not, I think.
Would not convict.
Yes. Yes,
What
would
is
not
the-
convict
what is the
because you have
guiding-
pride. Yes.
Yes. Which is the guiding case, the leading case in that scenario?
In prima facie case, the guiding case, I think we have some superior court decision. Can I remember of any light now? Maybe I'll remember as I go on.
Okay. At that point, what is the standard of proof you apply? In a criminal case. Yes, in a criminal case.
The
At
standard,
the stage of prima facie case.
I think it will not change anything because the standard will be the same for criminal case.
Beyond any doubt, beyond a shadow of doubt.
I would think because it's still a criminal matter that
Okay.
we don't have any other that we can apply at that time. Because ordinarily we just look at the precedent and see, is there any offense that has been disclosed? If not, then you want to hear the other side. So you either put them on their defense under section 200 or you don't put them to defense.
Okay, when you're making that decision to either put them or not to put them, how do you go about writing your ruling?
Ordinarily, if we are going to put them on their defense, is just say that I've considered the evidence adduced by the prosecution, I've considered the cross-examination by the accused person on that, and I have found that the
What
prima
by
facie
the, sorry,
case-
you mumbled something I didn't hear. You've considered what?
I've said if you are going to put them on their defense, let's say you are going to acquit under 210, section 210 of the CPC. So you say, I've just considered the evidence adduced by the prosecution, and I come to the conclusion that there is a prima facie case that has been established by the prosecution to warrant the accused person be placed on his defense or her defense.
That is when you're acquitting.
No, I'm saying
When you're putting him on his
on defense. That's what I'm saying. When you put him on the defense, you just look. It's a one-page statement.
Oh, okay.
Or I have a page actually.
Okay. What if
Yeah.
when you're acquitting?
If you are quitting now, that is now you have to make a very reasoned ruling, even if it will be 10 or 20 pages, because there must be reason why you have found that this person ought to be put not to be put on his defense. Because now we are talking of an acquittal. You are finishing the case by a ruling in that aspect. So your ruling is going to finish that case completely. So in such case, you must reason it like you could have reasoned under 215.
Okay. Now, why do we do that? Why is it that when you are putting him on his defense
Yes.
and finding that a prima facie case has been established, you do not give reasons, you do not make a lengthy ruling, you just make a statement. While when you are acquitting at that stage, you give reasons.
There will be right of appeal, and if, for example, if you put acquit under 210, there is a right of appeal by the DPP. So it must be reasoned at that time, very well reasoned.
Are you saying the others that if you are placing them on their defense, there cannot be right of appeal?
Under section 210? Okay, maybe what I would say, Commissioner, maybe I don't know whether I'm getting. Okay,
I just want to get the rationale behind not giving reasons.
He'll still have an opportunity to make his defense. When we are putting on his defense, he'll have an opportunity to say what he knows about his case.
Who? The prosecutor?
The accused person, when we have put him on his defense.
So you are not giving reasons for putting him on his
You are
defense?
not giving reason because you have already found there's a prima facie. You know you are not determining the case at all at that time. So there be no maybe purpose of going so many who are saying why you are putting him on defense. Because at the end of the day, these are only part of the proceeding from 210 to 215, all of them.
Praise yourself on the reasons.
Okay.
The decision of Festo Wendo versus Republic. You can look at that decision.
Okay, thank you.
It will tell you why we don't give reasons.
We don't give reasons.
Okay, thank you, my lady.
Thank you, Honorable CJ. Your Honor, I've read your particulars, your experience, how many years you have served, the judiciary and on the bench, and also your sample writings. Tell me, did you serve? I heard you mention Garissa and Garsen.
Garsen.
Okay.
Garsen, yeah.
Okay, you didn't serve in Garissa.
No, I said for Garsen.
Garsen, and where else?
Yes.
Where else did you serve?
I served in Nyamira. And
No,
then-
in this side of the northern part.
No, I've only served in Garsen for 5 years. That is the only place I've stayed more than any other station.
Okay.
Yeah, 5
In
years.
Garsen,
Yes.
did you have any alternative justice system?
Yeah, for matters, especially Islam, they were using Masala.
Muslim?
Yeah, they were really assisting us. That I thought I liked when I could work in such places where the Islam is the predominant, because they used to really solve their cases.
Is Masla Islamic or Somali?
Somalis, there were Somalis who were in Garsen. Yeah,
Yes.
but I think the principles
But
used
there,
is
there are also aspects of Islamic.
yeah, this aspect. So we
Tell me.
really is
Tell me, AJS is very good, alternative dispute resolution,
yes.
and we encourage it.
Mhm.
But did you get any suggestion to you,
Yes,
application of Maslaha settlement
yes.
in respect of murder cases or criminal cases, serious criminal cases like defilement?
Yes, what happened? There was a lot. There were a lot of attempts to come and say that they have reconciled on defilement cases. Actually, in Karsen, they formed quite a lot of them.
What was your approach? Did you
And of
agree?
course, yes, they'll come and say, jaji, mimi sisi hii kitu tushasikizana, tumetoa hii mtoto, tumepatiwa. They have reconciled and everything. And then I'll tell them that is against the law. You are not supposed to reconcile on the issue of matters of development, touching of the children, at all. And of course, in our COCs, one of the issues that people are raising is the issue development, because it formed a lot of cases in our system. And you can reconcile about grazing, illegal grazing, and all those cattle issues, cattle rustling, because they stealing
Assault.
cattle, yes, and all assault. But when it comes to issue of development, and they formed quite a number of cases, we told them, no, the law does not allow that. Okay. And it's only sometimes because of you are living, you have also to look at a society where you are living with, because I fell short of even saying that they should be prosecuted. Yes.
Thank you very much.
Yes.
And another issue, I saw that in two of your decisions, they dealt with the Muruatetu.
Yes, I dealt with the Muratote.
Yeah.
Yes.
Judgment application for sentencing after conviction.
Yes.
After Muruatetu
Yes.
was delivered,
Yes.
they applied for resentencing,
Yes.
considering this new jurisprudence.
Yes.
And I like the one where you are very clear when you are applying the Muruatetu principles. I think it's case number, sample number 3. You specifically said according to Francis Muruatetu, following guidelines are applicable in a hearing a sentence in a murder charge, and by no doubt a capital offense.
Yes.
That is murder. So
Yes,
you recognized
Yes.
that Muruatetu case was relating to a murder charge,
Yes.
which is a capital offense.
Yes.
Yes, and you applied. I think you applied your law. I applaud you
Yes.
for that judgment.
Yes.
The other second one you didn't specifically mention. That was a murder case,
Yes.
but actually it was a robbery with violence.
Mhm.
So from murder, you have applied it in robbery with violence.
Yes.
And I do know
Yes.
it has been applied even in Sexual Offences Act. And now controversy has arisen because also of the Muruatetu number 2, the directions. Now, the matters, many matters are sub judice, they're still pending. But what is your personal view? Should Muruatetu be applied to other cases other than murder?
Yes, thank you, Judge, for that question. We have come from Murwatetu 1, and that is Francis Karioko Murwatetu and William Viriba Mwangi, petition number 15 and 16 of 2015. And we all went like unruly hosts, I can say, that once taken out of the stable, you never know where it will take you. So the first case that came was William Okugu Kutuni, 2018, Court of Appeal, and it was on robbery with violence. And the judges went and said, but there is nothing that is preventing us from analogous. From there, everybody, the judges go get decision and all those. So they came there everywhere. Then before we came there to the sexual offenses, and we applied the principles because we say the Superior Court of Record has already decided on that. So after, I think a lot of decision came, even to Mainke case and all those, Court of Appeal, the Supreme Court again, I think after seeing so many confusion, I think they said there was confusion, gave in 2021, there were guidelines that they gave on the applicability. And after that, you are going to find this a case that was decided in by Kisumu bench in 2023 regarding the same, that was, I think it was Karaja, Tuyot, and Gugi. And what they are saying is, I see a problem where they are even really saying we need an intervention from the Supreme Court after giving the 21.
After the second.
Yes, after the Murwatetu 2, what is that bench saying? We need an intervention from the Supreme Court. We need do reform. Okay. And the judge said there's nothing that will prevent a common law judge from applying a prescriptive ratio to another case. On where, for example, the issue of judicial discretion is. So the prescriptive, they are saying you can still applying it, but for this one, it was never raised in the High Court. Okay. So it ought to have been raised there, so we shall not. But they are saying we be given still. So what does it now take us again? Okay. So I think we will still wait to wait for that.
All right.
Yes.
Thank you very much. I think you have a full understanding of that law. Now, finally, I would like to ask you about just one brief question.
Yes.
Administrative action. What do you understand by administrative action?
Yes,
and the Fair Administration Action Act.
Yes, we have one, the Fair Administration Act 2015. Number two, we have the article of our Constitution, Article 47, that they say the same should be lawful, procedurally fair, reasonable, efficient, expeditious.
Thank you.
Yes.
All the best.
Thank you, Jet.
Thank you, Honorable Chair. Good afternoon once again, Your Honor.
Yes, good afternoon, Commissioner.
How would you describe your writing style when it comes to judgment and rulings?
Yes, sir. My writing style is one, I see the issues which have been raised. So identify the issues for determination. And then once I identify the issues, I'll go analyze what happened in the lower court. For example, in my court, the evidence that was adduced, analyze the law, the evidence applicable, and then point for determination. Then I come to my judgment. Okay,
so then what is the structure of a judgment?
Structure, I think it is the way a judge would frame. In that case, the structure should be one. It should be dated, assigned by a judge.
Dated. That's at the top, at the bottom.
Yes.
Let's start from the beginning.
The parties to a case. Okay. The charge, if it's a criminal case, must be.
Let's work with a civil matter.
Yes. So you go to the plaintiff. What were the issues that the plaintiff is seeking? So you say the plaintiff in this case has sought the following one. That's one, injunction, two, compensation, and whatever. So that is the first one. Then you'll go to the issue of the defense was filed on this time and this, and then whatever other application could have been filed in that law applicable. You have analyzed the plaintiff, the defendant case, then the law applicable in that. So you quote the section of the law, the evidence that was the section of the law that is applicable, the case law and everything. Then from there, you'll be able to give your determination on that case, so that you say, I've applied this case that was decided in the Supreme Court, and the defendant will not be able to succeed because of this, and the plaintiff will succeed in the claim because of this and this. So now there you will give your prayers. Number one, if you are rejecting, why you have rejected the defense, then the plaintiff in your prayers, only your final determination will be say judgment for the plaintiff, special damages given, why they were not given. You have already analyzed general damages, cost. The issue of cost, to be able to look at the circumstances of the case, whether is it payable, is it not payable. So that is the discretion of the court. If the cost for letters are not, you find that it's not prudent to make, you give a reason why the cost. For example, close family members, you say, I will not give an order for cost because of this and this, the circumstances of the case.
And what is the importance of editing and proofreading a decision before it's published?
Before a decision is probably, it's good to edit it. It's good to so that it leaves no doubt as to what the judge wrote in that case. But to ensure also these enhance public confidence in a way that you can imagine that you publish a matter in there. It is read by everybody, but it has some typographical errors. So you are not going to have any public on trust on that.
So with regards to the sample writing you shared, you write very well, as Judge Ibrahim has mentioned.
Yes.
But during the course of this exercise, you did submit to us another decision.
Yes.
It's a land matter decision.
Yes.
In ELC number 49 of 2020, Rebecca Damiano versus Shadrach Kikuri. And I'm just reading, after reading the judgment,
Yes.
I don't seem to understand why you did not adhere
Yes,
to what you have just stated in terms of the contents of a
Yes.
judgment.
Yes.
In this particular case, at the introduction, you mentioned what the plaintiff, but when you went to the defendant, you just said the defendant filed his defense and also a counterclaim.
Yes.
You did not particularize
Yes.
what the counterclaim was.
Yes.
In addition, when you're summarizing the evidence produced, you would only mention she adopted her statement and produced exhibits PE 1 to 5 without highlighting what
Yes.
exhibit 1
Yes.
is, exhibit 5,
Yes.
blah, blah, blah is.
Yes.
Again, within this particular decision, the reference was referred to land parcel number. I'll not speak to the first sections. I'll only speak to the actual number, that is 343.
Yes.
But you again, in your judgment, mention land parcel number 33741.
Yes.
Again, you go ahead and mention that the defendants actually appeared in court. They adopted their documents.
Yes.
They adopted their statement in evidence. They adopted their statement in evidence and produced their documents. Again, you proceed to list
Yes.
evidence D1 to 7 without
Yes.
exhibit D1 to 7 and 8 to 9 without detailing
Yes.
what those exhibits are. I think you do this for all the defendant witnesses. Again, you introduce another parcel of land,
Yes.
3142. The issue of coherence and flow.
Yes.
If you are the judge, somebody has appeared before you with this type of decision.
Yes.
Do you think it will be easy for a judge to even try to comprehend
Now,
what you are trying to communicate?
okay.
And
thank
even
you.
some of the orders you have indicated,
Yes.
there's no coherence. There's one part you're saying the land, as such, the orders that the land was erroneously registered in the name of the plaintiff
Yes.
cannot succeed. The same happens with the orders of rectification of register, as the said office is a party to a suit.
Yes.
So there is no coherence. You do not cite any
Yes.
decided case. You do not give reasons as to why you arrived at the decision you did arrive. You did not even mention why you're dismissing
Yes.
the counterclaim.
Yes.
Still on this case, on 25th of May,
Yes.
that's about 4 or so months later, when you deliver your decision, a party appears before you for an application under certificate of urgency. You say that application is not urgent. The applicant to take dates in the registry in the usual way and serve.
Yes, okay. Yes.
My mark went off. So I just want to understand why the ones that you gave us were well detailed, but this one that came to us through a letter we had reached out to you
Yes.
is completely different.
Okay, thank you so much, Commissioner, for that. Well, if you look at when I finished that case, the decisions I rendered within 3 weeks. Yeah, the decision from time the matter for submission came was on 7th, and on 28th I was able to finish those matters. Yes, I would agree not go to all those lengths. But one thing maybe I would like to clarify and say that if you look, there were so many issues. Those land puzzles, everybody, there was the main puzzle of land, but had been subdivided into various puzzles of the land. But if you look at the one which was on location was the 343. That one. So if you look at the defendant, they were mistaken that what even the claim the plaintiff had brought was under 343. So I went into chronology to say these are the, because they are there. If you look at even the pleadings that's applied, you are going to find their various titles. So they had emanated from that main case. So on the other issue of I did not quote authority, and yes, sometimes I would say that pressure of time sometimes come. This time that on that you can say I had if you look at my documents that I've touched, I delivered six judgments on that day, and they were all of them were very contentious. And
I just because of time,
Yes.
for me it's so. Are you saying you focus more on quantity vis-a-vis quality, and how can you say that this particular judgment that you delivered is accountable? How can you account for the people of Kenya for your time and the resources in terms of what is expected of you?
Maybe what I can say, Commissioner, I could have maybe extended time for myself. I had my own personal challenge. Sometimes you get some personal challenge that you want maybe to deliver judgments, you don't want to leave them hanging. So it is on that basis I delivered those judgments, that judgment on that, and the others who are there.
Okay.
And sometimes some of these things happen depending on the time.
So do you think by virtue of what you have written, not the contents in terms
could have
of
been, was there, maybe I could have given the decision after maybe 60 days because I had so much on my tip on that day. I could have maybe expended time on that.
and do a good job.
Exactly, a better one
Okay.
than.
Thank you.
And it can be seen all my judgments, even where I've worked, you can see the way I reason. Like the election petition, I did it.
No, I'm okay with that, Council. It's just that's why I said
Yes.
when I looked at what you submitted, they were well written. But now what you submitted to us thereafter, there is a problem.
Yes, sometimes,
So my question is it qua ground? Is it what we'll find this qua ground?
Exactly. That go to Garsen, go to Keroka, go to the ELC.
Thank you.
Yes.
Thank you and all the best, Your Honor.
Thank you.
Cheers.
Thank you, Honorable Chair. Mr. Masharia, Honorable Masharia, did you get a copy of the report from Directorate of Performance Management?
Yes, I got.
All right. What was your case clearance rate?
I think it was quite low. I think it was around 8. I don't know. I have not looked at it in the morning, but it was quite low. I think it was 80 or something. I'm not wrong.
It was low. When did you look at it?
I think a week ago.
And what you're saying is that it was low.
Let me say, I've not. I was sent that one when I was in Tigania. Let me say, I've not had opportunity of really looking at it recently when I was coming here. But I know our performance. My performance is okay. That one I can guarantee. My performance, I know it because I've come with my performance.
Overall performance is indicated to be 147%.
Yes.
And that in terms of case clearance rate, it's 49% out of expected 33%.
Yes, that one I remember, 49 to 33.
All right.
Yeah, that one I remember.
So from this report, you appear to be doing well.
Yes.
Because you've exceeded what is expected of you.
Yes.
And so all I can say is that keep up the good work.
Yes.
Yes.
Yeah,
Thank
thank you so much.
Thank you.
Yes.
Thank you, Honorable Chair. Now, would you explain to us, or at least list to us, the principles that guide the exercise of judicial authority?
Yes. Article 59, judicial, I think that is what you're saying, is vested from the people of Kenya, and it should be in accordance with the Constitution and the law. Justice should not be delayed, shall be done to all equally without delay. The court must adopt ADR and the AJS mechanism to expedite the case. At all times, the court must promote purposes and principles of the Constitution and Article 159 of Kenya. Yes.
Just pick one principle and tell us how you have applied in your course of work.
AJS, ADR. That one I think I can tell. Yes, maybe I can go back to.
No, pick another one, because that one I think you explained very well and comprehensively in your introductory remarks when the Vice Chair was engaging you.
Yes.
Yeah.
Yes, expeditious trial had also doing equality. I had Article 27 of the Constitution that allows to equality, and discrimination should be or be practiced. When, for example, I'm dealing with my matter, when I was in Garusen, I did not favor any part, whether it is Pokomo or Oroma. I was not in any way casted in bad light that I was, because at that time we may run the risk of going against one side. But at no time was I told that I am not impartial, that I am not doing my work. So expeditious trial, if you look at my performance, I don't delay judgments. And the record can attest that at the same time, we have been having a consistency record of 100 performance. Delivery of the judgment at the first instance, 100%. And if I had those documents, I could show when I was Garsen. So I make sure that expeditious delivery is one, deliver your judgment on time, expedite your trials. I did a petition in Nyeri, and I delivered it 2 months, 62 pages. 2 months, I was able, I went for recount, I went for scrutiny, and applications have been made for scrutiny, and within 2 months, 62 judgments, I was able to come with it. So I make sure that the people, I always ensure that it is expeditious. Where I'm doing, I ensure that I'm impartial. When I was organized, I did not, and some other 160, these are the independence of the office of a judge, yeah, that no suit or can be brought against us having judge, yeah, for anything done in good faith. We have things like public participation aspects, maybe at Article 10, I can go there, where we involve the citizenry in the decision we make, so that to has accountability. Okay, we have acts of parliament like Public Audit Act that ensure that what we do, we are up to the task. We have control of budget, and which is an independent office that ensures our budget. Judiciary does the budget they are supposed to do and consumes it. We have the Auditor General, which is also independent. Auditor General can come to the judiciary, ask for document, ask how are you doing this work, and all that. So we have those acts, participation acts like public participation, and the acts of parliament, independent body, or Auditor General, and
Chair.
Thank you, Honorable Chair. Mheshimiwa, 2 very brief questions for you. One is from the report we have from prevalence.
Yes.
At Tigania, according to the last survey, was at 11.54 against the average of 7.03 countrywide. What is happening there, and what is the current situation? How would you describe the current situation if we were to run a survey now?
Okay, I think the report, I was not there, let me just own up, it was 2019. Just to say, when I was in Garusen for 5 years, my corruption index, which can be seen by anybody, 0.00, 2015, 2016, 2017, 0.00. The other year, 0.00. All the years, consistent.
That's fine. 0. I'm asking about Tigania.
Now, in Tigania, there's a problem. Problem being, we had just come from advocate striking. The other judicial officers did not even stay for long. So in other words, there was lack of public confidence in Tigania. That one I can tell you. A lot of suspicion which are there. So the first thing I did was to do the my CUC on my bar bench. Okay? And ensure, like that case you are talking over, all 5 years, 6 years matter. Make sure that plaintiff come. If you come with one witness close, defendant come. If you only come with one witness close. So there's no piecemeal hearing of the matters. Number 2, brokers. If there's a court that has brokers in this world, go come to Tigania. Brokers are flying everywhere. Advocates who do not have practice certificate, they are just offices there, and they did a swoop the other day, and they closed all those offices where an advocate leaves an office, and then other person, even people who are not as advocate, they were all closed, so that we enhance public confidence. The issue of broker, personally, I make sure that I ask you, what are you doing in my court? Have your matter been handled? I do that, walking around and ensuring that no person, because I know they are the one who do take money there. They come, then they say, I'll see a judge, and that is what has been leading to this. Yeah. So I have ensured through my own that these brokers are going to be by force, by fire. They will not stay in Tigania. They find another place to go, because I'll make sure that everybody must even have cases where advocates have been charged before us. And we said we are going to take that case because the magistrate is a complainant. But I said I was not even here when the office commented, and it's me. I don't want to go to detail. So that is one of the ways that I'm going to ensure that. 2, we had a staff meeting, and the first thing I told them, reform will perish, because there's a lot of indictment. People are talking so many things in there, saying that their documents are being filed, they are missing this. And we agree that we are going to have a way of dealing with people, make sure that there's transparency, there's accountability. Everybody from, I introduced movement registers very clearly. When a file lives there, this is where it has, this is where it has come, this is where it has come. Movement register, so that no one will at any time say, this file is missing, I don't know where this file is. So I have really come with very clear mechanism of ensuring. Now I have a customer care desk, very effective. I established a customer care with a good side. 2, I have put now another one, suggestion box, one on the other side of the court, and if you come, you'll see that 182 people has a key, the EU and another staff, so that whatever comes there, minute it here. I was not satisfied with my case delayed in court 1. Either evening, let us look. EU, come with that book. What is these complaints I'm hearing? People went to the register, you delayed. What is happening? So that is another way. Very effective customer care desk, so that anybody in doubt, there's one person who is known and who is managing that. We look at our suggestion box. What are people saying? Their keys are delayed, or what are they saying? So we look at them, and then through our leadership and management team, we have come with a very peer review mechanism, so that if you know there's a person who is not doing the right thing, can you peer review this person? Even us as a magistrate, we have our own peer review mechanism where we look at each other who is not doing the right thing. There's an issue that is already, and we did do it in a very, very friendly manner, so that no one will feel stigma side and all that. So our CUCs, we told them, you are our ambassador of this court. We may not be right 100%, we may be 70, but when you get there, make sure that you give image to our court. Because what they do, when they are dissatisfied, they go to Kameme, and I know there's the Zero, it's those kind. So you'll hear things there. So we say, are we going to prosecute judicially because you are not satisfied with something? You run to why there's one head of station, James Masharia. I've written it clearly. If you are not satisfied with the regional service, see the head of station, James. Everybody knows my name.
Okay, Mheshimiwa, that's fine. We hear you, and I think on that front, we can only wait to see the next survey, and I'm hoping it will be at 0.00, like you said.
No, I'll do. It is a heinous task. I'm not saying that I'll give a result by tomorrow or any other day, but I normally believe step by step.
Okay, that's fine. So my final question: give us 4 top qualities of a judge that you can think of. Just 4 briefly.
Yes. One, I'll think of the integrity. A judge, whether in public or in private life, must conduct himself with integrity.
Next.
That is the Judicial Code of Conduct. We have the Public Ethics Act 2003, and we have Article 73 and Article 10 of the Constitution and Article 159, which guides that.
Yes.
The other one I'll do is I'll talk of independence. and the impartiality. Maybe I don't know whether I can mix them. Independence is that under Article 161, my decision, no one can tell me to come and talk shit or do anything else. I must be independent. I will not be influenced by what the media is saying about a certain case. Like when I was doing that election petition, so many things were being written all over. Oh,
Okay, I just said you mentioned,
I mentioned
so that we can move
independence,
faster.
Impartiality, you must also be impartial. And I'll talk about maybe we talk of impartiality, independence, propriety, so that you conduct the way you conduct yourself, a confessionary accepted standards of a judicial officer must be there. Accountability, you must be accountable to the decision you make at all time. When you go anywhere, anybody will be able to see that yes, I'm accountable to what I've done and everything like that.
For one to be a successful judge, they need to have good listening skills, right? Do you agree with me?
Very good listening skills.
Do you think you're a good listener?
Sometimes it becomes difficult for one to talk about himself. Eh?
No, I'm just asking.
Yes.
Do you think you're a good listener?
Yes, me, I can say I may not be 100% good, let me say, because no one is perfect in their own way.
Okay.
But me, I do the best to try to listen to people.
Okay.
When they have appeared before me, I'll look at what you have come to complain in our meetings. In fact, if you look at our Babbage meetings, you're going to see the way they say that they are really happy with it, because I listen to issues that they have risen. So when we have a meetings, and our CUC has become very strong now, because I normally listen to them. I ask them, it's not me, you are the people of Tigania. In a rural setting, a court in a rural setting, tell us how you want us to put. So I reason, and then I actualize. I don't do what I think.
Okay, that's fine, Mheshimiwa. Thank you, and I wish you the very best.
Thank you.
Thank you, commissioners, and thank you, Honorable Masharia, for this very engaging interaction. Oh, there's a matter. Okay.
Sorry about that. There was a complaint which you are served with, I'm sure, by the commission. And of course, you are aware that we normally seek views from the public because it's part of the accountability mechanism, and you're supposed to operate under transparency, rules. Now, it is alleged that this a complainant, somebody called Shedrack Kiruki Mlaria, who alleges that there was a matter that was filed. It was a land matter, and where there was a plaintiff who sought an injunction against the complainant in that land matter, and the complainant in return filed a defense and counterclaim where he gave particulars of fraud, which he claimed that the title that the plaintiff was seeking to rely on was a fraudulent title, and he sought the rectification of the register.
Yes.
Now, it is alleged that the matter was previously heard by a different judicial officer, Honorable Munyi.
Yes.
Then, when you came to Tigania, you took over the matter and now had the defendant's case, and you delivered a judgment on 28th of November 2023, where you agreed with the complainant and dismissed the plaintiff's case and allowed his counterclaim. That's what he says.
Agreed with the complainant?
Yeah, he says that you agreed with the complainant, the defendant, where you dismissed the plaintiff's case and allowed the complainant's counterclaim. In effect, you agreed with the complainant, so you ruled in his favor, or you judged in his favor. But now he states that subsequently you rewrote the judgment and now did a second issued orders that were opposite of that were in direct contradiction with the orders that you had previously issued.
Yes.
That is his complaint.
Okay.
And he says that he subsequently filed an application seeking for you to set aside that wrong judgment according to him and replace it with the right one. But you didn't certify the matter as urgent. So in effect, what he is saying is that you are not fit to be appointed as a judge. And he says that, he's questioning the integrity and impartiality of you as a judicial officer. You are served with this complaint and you did put in a response. So you have an opportunity to respond to that.
Okay, thank you so much. Yes, the commissioners, my lady, I got that complaint by, actually he was the former commissioner that I was came to know of police. It was the Shadrach Kiruke, the former commissioner of police. That matter was not heard by me. The positive case was heard by Honorable Munyi. There also one defensive witness that was not heard by me was heard. So I came to cover. I had 6 cases in one day, and I closed that case. Now, the judgment that was delivered, I don't know which one they could be having to say this so that they say I contradicted. It's very clear the decision which I delivered. It is the defendant counterclaim. And he was the defendant in that case. So it is not even what he's saying that the plaintiff's claim. So it is the defendant counterclaim which was dismissed and the plaintiff came allowed. Now, when I got such that letter, the first thing is to go to my court assistants, go quickly to the file, go quickly to the CTS, you look. So I asked my court assistant, can you, what happened? He goes, copies of CTS and everything I have done there. So if you look at the CTS, what my court assistant wrote is defendant case allowed. There was no issue of the plaintiff case, whether it was at that judgment, he looks at that judgment, he looks. And what does he tell me? I remember this case that for that police, and I highly regret. When they came, one thing in the CTS, because that was contra entry, ought to have been 2 entry, case for the plaintiff allowed for this defendant to be dismissed. So he left the case of the plaintiff, but very well a lot for the case of the defendant that it was. So I asked for the CTS and everything. And if you look at that complaint, it is the defendant case, which is the judgment and which is on record. So my court assistant tells me, no. I had told them, I remember the 2 men coming that day. And I told them that it is there, he has won. But I said, so what is the CTS now? And I wrote that to the CTS. So what he is saying he had may say is that, there were 2 contra entry, plaintiff and whatever, but he only entered 1 issue, defendant case allowed. File closed. So he missed even one, the other entry. So, but he has confessed through an affidavit that this confusion arose from my error, because when the plaintiff came, it is me, or when the defendant came, it's me who told them that. Now they have hitched on that to say, and he has even dedicated in his advocate, it's me. The whole confusion arose because I thought, when you tell a defendant he has won a case, what do you think will happen? So those judgment, one thing, virtual platform, even if a person is so a criminal or a person who is not even of low moral conduct, that you can see this person, I don't know, we are dealing with a criminal judiciary, in a platform, virtual platform, and you tell a person, because even the advocate is saying, I also heard that, that is what I heard.
Mheshimiwa, just a clarification. Now that you're saying that your court assistant told the defendant who is the complainant that he had won, and also even entered the same thing in the CTS, which means that the complainant reasonably, you can also say that he was unreasonable in arriving at the conclusion that he had won, because this is your court assistant, this is the CTS, which is it's an infrastructure belonging to the judiciary.
Yes.
So what steps did you take against the court assistant?
Yes.
Because as you are saying, you have issued the correct judgment, but the court assistant did, the opposite. So what steps were taken against the court assistant?
That complaint came to me on Monday. The time I realized that there is this person who is complained, and I was able Monday. Yes, so I was able to look at the complaint. I was in Nairobi, so I've not had the opportunity. So one thing I told him, can you own up in an affidavit that is you who entered everything wrong? He has owned up that it's me, and he's very sorry on that. So I'm waiting to go back to the station.
Okay.
Look at the file. Look at the administrative procedures I'm going to deal with. I know how to come with that.
Yeah. Do you find that unusual?
Yes.
Do you find that unusual for a court assistant
It is not. When that's what I'm going to interrogate. I've not had. I want to have a sitting. I look at all the documentation. I do my own assessment, because when you talk on phone, it will not. So I've not had the opportunity to go back to face him. So that why others, because those times, if you look, I delivered 5 judgments. Virtual platform. If a person wants to, can you really say anything on a virtual platform and then really virtually? A person in Uganda, a person in America is here. You come and you even if you're not even a criminal, you cannot do that.
All right.
Or a person who is so deficient. And when we came to JFT, Honorable Mutuga CJ said, we found an institution so low in its confidence, so weak in the public support, so deficient integrity, that accountability mechanism were missing and reporting mechanism. We found an institution that was designed to say, the Office of the Justice acted like a judicial monarch, supported by the Registrar of the High Court. I worked with this JFC, JS.
My colleague wants to ask you a question.
Yeah, thank you for clarifying that, but I just want to follow up on the issue. If at all it was on virtual platform, wouldn't it be easier and neater to ask the ICT department to transcribe what transpired as opposed to going to a court assistant to swear an affidavit? You know, there's that issue of power dynamics.
Yes.
Is it to blame the court assistant and the court assistant accepting?
I've already asked
because
for
just listen before I finish up. And then when you look at the entries, this is a CTS entries. It even indicated what was uploaded. There is the flow. What is uploaded is the case. The case is dismissed with court file closed. Submissions are filed. Okay, I don't know how the flow is, but there is a place that reads the same is delivered. I don't know that it's the same because you've attached a series of
for judgment for the same day.
Or judgments for the same day. Okay, for this particular one, Rebecca, let me just because I have seen what is uploaded on the system is that the defendant's case is I think I mixed up. Just give me 1 minute, Rebecca. I didn't know there were for many cases, but there's one that reads I just can't trace it here, but I forgot to mark it. That reads case dismissed and the defendant's matter something. Maybe you can, Chief Justice, you can proceed because I can't seem to get the exact attachment. I think it's here. The same is delivered in favor of the defendant, file closed. And this was done on 28th of November, 2023. And then, as I said earlier, on 23rd March 2024, there was an application which, according to the ruling you have presented, we can't even tell what the nature of the application. So your orders is from these CTS parties to take another date that cost in the course. So there is a likelihood then at this particular time when you are hearing this application, you ought to have then clarified to the parties what actually transpired before the parties coming to the judiciary. So you had opportunities to explain to the parties that, okay, there was a mistake on 28th of November, and we will amend the CTS, but this is the decision. So the opportunities that you've had to explain before the parties coming to the JSC, why didn't you use those opportunities?
Thank you, Commissioner, for that. Let me be very genuine. I learned about there was an issue with that file when I was served with the complaint. That is the time I realized that there's a problem with that file. So even when it was coming at a certificate of urgency, because the certificate was just saying that you change this. So I go through my judgment. I say, my judgment, is it that the applicant is mistaken on what transpired on this judgment? You see? So I did not at any time that time know that there was anything, because if I could have known, I could have called the parties and told them, look, this is confusion that arose.
Thank you. Yes. But there was an application telling you that there is a mistake.
Yeah, but it did not specify. It was saying there was an error. So an error could be. It was just talking of error.
Thank you, CJ.
Yeah, Judge, I've learned so many. Sometimes things happen, and when you're in a hurry, you can want to, at the expense of maybe wanted to deliver all your judgment. I mean, I don't delay judgment. Sometimes you may hurry, and maybe you like something that judgment may not be so much detailed. But I can assure you, when I'm the court of high court judge, my procedure is as you have seen with all my cases decided. Sometimes these happen, you want to find those cases which have been 6 years, 7. So you deliver a judgment, maybe 10 pages, 6 pages. So when we go there, everything I say is a learning lesson. So that I always ensure CTS is well done before everything. I personally take responsibility of calling for that day. Sometimes it's not possible, but I'll take upon me to see my judgment and the CTS so that there will be no confusion. So those are things I'm learning that being accountable. You need sometimes to just go out of your way.
Okay.
Look at every file that was there. Go through
The commission has noted that, and we would like to work with you this journey to support you.
Yes.
So that you don't make those mistakes, especially when you are overwhelmed by work.
Yes.
If you are driven by good faith.
Yes.
So I think this brings us to the end of the interview.
Well, I have no question, but can I say something? Not a question.
Yes, you can.
Yes. I think I've been tired of engagement with the judge of appeal, with my lady. I've never had a personal engagement with my lady. The Chief Justice,
Yeah.
I've never had personal engagement at such a form of environment with my commissioner and with the two people representing the PSC and the one representing the members, and also Masharia. I've been seeing him on the TV. I've never come close to him. And also the other commissioner, and also Mohammed Ibrahim. I knew him as an advocate those years. So I say sometimes it's also interacting. I'm also knowing each other more. There are always lessons to learn. Here you did. And also I'm very happy that you shortlisted me, showing faith out of 300 that Masharia James should come and defend what he knows. Okay. So I say, may God guide your decision as you come with the other list of the people who succeed.
Thank you. I'm sure the commissioners were also happy to interact with you and hear of the unique nature of the cases that you are dealing with in Tigania, and next time they are visiting the courts.
Yes.
I believe that will be another court to visit. Yes. So take our greetings there.
Yes.
We wish you well.
Yes.
We can see your hands-on taking, judicial leadership. Just take time to listen and to make sure that you don't make mistakes that can cost you a lot of anxiety.
Yes, ma'am.
Yeah, so we wish you well. We'll get in touch with you when we complete the exercise.
Thank you and welcome to Tigania anytime.
Yeah, thank you.
Asante.
Give them our regards.